have a patchwork where voters are going to be treated differently and affected across the country. And that is somewhat chaotic.
Isn't part of the answer to that if we were to say that President Trump can't be on the ballot here, there's a very high probability that the United States Supreme Court would step in and decide what the standards should be, one would think, so there wouldn't be the same potential for the chaos that you're describing. Is that not a fair response?
Well, President Trump would certainly think that, yes, we would want to appeal it. But I don't think that the court should rely upon the hope that the U.S. Supreme Court will step in. The standard is we should look at that in advance and prevent that bad situation from occurring in the first place. Those are the prudential concerns.
Well, let me pick up on, and really the point you made, which was we have this today. We haven't had chaos in well over 200 years. I mean, states have these authorities. California has one mechanism, New Hampshire has a different one. I'm not so sure that we have the crisis that you might suggest.
Those mechanisms are procedures. They're not the substantive application of Section 3. There is a difference there. When we talk about procedures, yes, New Hampshire has a different set of laws for qualification than Colorado. But those are all different procedures. They're not the substantive application of a disqualification standard.
Forgive me, Mr. Gessler, so let me ask you about that. So can the Secretary of State disqualify a candidate who is not born in the United States?
That's a question. I don't think there's a statutory authority for them to do that. Now the petitioner has said, well, Hillary Rudy testified to this and that, and deep respect for her, but that doesn't define what a state's authority is. We have 1204, which requires a statement of intent. And the question is the form for 1204, does that carry the force of law? That's really sort of the question.
Well, it's a constitutional qualification. That's why I was asking the question. I mean, there's some suggestion that we should look at different qualifications differently. The 35-year age limit and the born in the United States are one thing, but the 14th Amendment is something different. That's what I was asking.
Right. First of all, I'd say the 14th Amendment is not a qualification. It is a disqualification. And in fact, if we even look back to McKee's original introduction of that legislation, that talked about qualification and holding, whereas Section 3 only talks about holding. So I would probably not concede the point on qualifications.
So actually, to that, and I know we're going back and forth between political question and I suppose the question of whether Section 3 is self-executing. But as you say, it's a disqualification. The only thing that the 14th Amendment says that Congress can do is remove the disqualification. Doesn't that suggest that the disqualification attaches independent of any act of Congress? Otherwise, they'd have nothing to remove. Did they have to say that Jefferson Davis met the definition of an insurrectionist under the 14th Amendment?
I would disagree that Section 3, that last clause, can't be read in isolation from Section 5 enabling legislation. And the Section 3 congressional action is more akin to the powers of a presidential pardon. It's essentially a pardon mechanism. And I don't think one can draw the inference that forecloses or affects the substantive law that allows that disability to come into effect. You look quizzical, Your Honor.
I am in fact quizzical. Go ahead.
Justice Gabriel, where are you going? So you mentioned these prudential considerations, and let's avoid chaos. One of the counter arguments is that by failing to resolve this issue on the merits now, we create the potential for chaos in January of 2025, and so. There's much emphasis on this in the scholarly literature about how it may be better for us to try to resolve it sooner rather than leave the potential for a constitutional crisis after the next presidential election. What's your response to that?
The response is not if we follow what I call the rule of democracy, what Attorney General Stanbury said in a couple instances, that when there's uncertainty, the disqualification doesn't apply. Ultimately, if the Republican Party chooses to take that risk, the Republican and unaffiliated voters in the state of Colorado choose to make that choice, that is their choice. it should not be foreclosed from this court.
Well, what do we do about Timmons then? Where in the what do we do about Timmons, where the U.S. Supreme Court says there's no absolute right to put someone who's not qualified on the ballot?
I would.
And we're talking about a political party here.
Right. And I agree that there aren't absolute rights, but there's certainly a minimum in ambiguity here. We don't think so on with respect to our approach. But the Timmons and Wisconsin ex rel follett cases nonetheless stand for political party First Amendment rights. That even if state law, for example, in the Wisconsin case, even if state law mandates one thing on how to assign delegates, state party rules prevail.
So your view is, then I would take it, that if either party wants to put on, we'll say, President Obama, or someone who's 20 years old, or Arnold Schwarzenegger, they have every right to do that.
Conceivably, yes. Now,
Wait, you say conceivably. What do you mean conceivably?
Well,
They are your own thing.
I was about to go for it. Look, I mean, Hillary Rudy testified, and it's not unreasonable, her testimony, and she said, look, the secretary can be involved in using the form for the 3 Article 2 qualifications, if it's an objective, knowable fact.
So then if it's a fact question, the secretary can't. So if there's a question about whether the person was born in this, was or was not born in this country, the secretary can't act. But if it's objectively, nobody doubts it, then the secretary can. That's a tough standard.
I agree. That was her testimony, and that was her escape valve when pressed on that issue.
But what is your take then on 1204 and the ability of an elector to challenge, let's say, the Obama example, where the 22nd Amendment would prohibit him from serving because it limits a person from serving more than 2 terms as president. So let's say President Obama wants to be on the Democratic Party primary ticket, checks all the boxes, unlike Hassan, checks all the boxes, tenders the statement of intent. Can an elector challenge his qualification under 1204, and if not, why not?
I would say no. First of all, from a broader constitutional preemption justiciability question, Article 2 doesn't quite face the same self-execution issues. The courts are split, but the weight of authority has been, because those cases were litigated, the weight of authority with respect to President Obama, Senator Cruz, and Senator McCain, all of whom were challenged on natural-born citizenship. The weight of authority is that states do not have the authority to be able to consider that. That's
Does it
the
matter
weight.
that most of those were decided after the person was elected into office? Does that matter?
Not in that aspect, Your Honor. It does matter because we would submit, and we have said before, that this court should have never exercised jurisdiction because of the complexity of the issues, the truncated procedures, and the inappropriateness of the 113 in this instance. So I think that was more of a function of the time, and they weren't considered moot because they were capable of repetition. So I don't think that matters, though.
Sorry. What does 1204 do then? What can you challenge under 1204 for?
1204, let me step back. Remember, 1204 mandates a hearing within 5 days of the petition, and it mandates a decision within 48 hours. So, and it specifically refers to Section 113, which requires a duty under the code. So that, with that structure in mind, 1204, the very structure of 1204 contemplates a very limited proceeding. And the limited proceeding is set forth in the substantive provisions of 1204, I believe it's 1 and 3. So, for example, there has to be a certificate from the state party saying that the candidate's a bona fide candidate. The candidate has to be affiliated with a party that had received at least 20% of the vote. The candidate has to fill out a statement of intent. Questions as to exactly what the content of that statement of intent is required. There's no rule or regulation that the Secretary has promulgated. It's merely a form which, according to Hillary Rudy's testimony, never went through the process. It was created by people within the office and reviewed by their legal counsel, and that was it. But those are very limited requirements. And under 113, there is not a duty. So to the question, if I may use that to transition a little bit to the 113 jurisdictional issues, could the Secretary of State simply said, I hereby make the determination. I think it's an obvious knowable fact, as she has said on TV. It's an obvious knowable fact. President Trump engaged in insurrection, therefore I keep him off the ballot. Let's say she said that. Does she have the authority to do that? I think the answer is no. She admitted she doesn't have the explicit authority to do it.
So
I think the court correctly recognized it.
I apologize, Mr. Gessner. I guess I just keep wondering, well, then what are we supposed to do, right? So there has to be some mechanism for review, doesn't there? And under your interpretation of things, is there really any?
To the extent, the way this would work would be the way Frazier suggested. I didn't disagree. I didn't agree with Frazier, and I don't think you did either, Justice Gabriel. But I think this case proves the correctness of Frazier, although I hate to admit it after 20 years of litigating this very issue. What the person would need to do would be file a declaratory judgment action outside of 113 to enforce the 14th Amendment.
Would the DEC action be in federal court where there's a likelihood that the person wouldn't have Article 3 standing?
Funny you ask that. Yeah. Because it was brought in this very case.
Oh.
Remember, there were 2 counts in the petition.
Right.
One was a 113/1204, and the other was a DEC action. We removed it, snap removal to federal court. The petitioner said, no, you can't do that because we have no concrete or particularized basis. So it has to be in state court. There's no federal jurisdiction. So it gets bounced back to state court. Then what we do is we say, well, you don't get the DEC action either because those are the same standards Colorado follows. After which the petitioners say, well, you're wrong, but we're still going to remove it in order to streamline the proceedings, which weren't streamlined because we litigated the entire constitutional issue nonetheless. But the DEC action would be the proper approach. Mm-hmm. The DEC action would be the proper approach, and they would be required to meet the standing requirements, as other litigants have across the country, and these other issues in a, at most, preliminary injunction context, but also affording time to properly litigate them.
I guess what I'm looking for ultimately is a meaningful opportunity for review, and that doesn't seem like one, at least and maybe the history of this case demonstrates as much. So are we just stuck, I guess is the question?
No, I would say it's completely a meaningful opportunity to review. And look at Kuhn, okay, Kuhn versus Williams. If you remember, that was a residency issue. This court bounced to there were 2 issues brought. One was a constitutional saying that the residency requirements are unconstitutional. This court bounced it, saying you can't bring a constitutional claim. Appropriate under Frazier. So what did the petitioners do? They immediately went to federal court. In that case, and Judge Blackmun in federal court said, you're right, they're unconstitutional. So there was adequate time for review of that constitutional issue in federal court. That was done under a preliminary injunction context, so they required a heightened standard of review. But that procedure has worked and worked fine.
Let me ask you, Mr. Gessner, you rely a lot on Kuhn and Frazier. Do you not see those as distinguishable from this case? In those cases, there was a 113 action, and there was a 1983 proceeding challenging the constitutionality of the residence requirement. That was a separate claim, not within the 113. Isn't that different than here? You say here the 113 action was a constitutional claim. Do you not see those as different?
No, I don't think this was an independent claim as well. Look, I mean, this was dressed up as a 113 and a 1204 action.
But let me push back on you a little bit, if I may. So if there was a 113 challenging the qualification of, whether you're a citizen of born in this country or whether you're 35, I think you'd say that fits within 113. So if this is, and I understand you disagree that this is a qualification here, but let's say hypothetically we disagreed. That would fit within 113. I think the other side would say this was an issue about whether President Trump is qualified.
I think you'd have to look at the nature of the litigation itself. Okay? So I would use 2 or 3 different frameworks. Let's put the shoe on the other foot. Secretary rejects in an administrative basis. President Trump then has to sue. What do we sue under? We would sue under the 14th Amendment, and we would sue under the First Amendment, the Brandenburg Standards, saying he didn't engage in anything that incited violence. I'm sure the Secretary, properly so under Frazier, would say, no, you're challenging governmental action. You're challenging my action under the Constitution. You can't do that under the Election Code. You have to do it in a declaratory judgment action. Now, here it's reversed, but it's the same concept.
Why wouldn't you therefore bring it under 113? I guess, why would you start with a losing argument? I'm confused by that. There are lots of kinds of actions where the primary thing that's litigated isn't the underlying basis for the suit. I think about any kind of malpractice case. the vast majority of a malpractice case might actually be the underlying claim, like a legal malpractice case, the claim that was lost. But it's still a legal malpractice case. It's just that you spend most of your time talking about whether you lost the claim that you could have had. So the fact that a lot of ink was spilled and words were spilled on the Constitution doesn't make it a constitutional claim.
The mere fact, I would agree with that. However, I think this differs, that this was in fact a constitutional claim. This whole thing is about constitutional litigation. There's no, look, the court recognized there's not a duty for the Secretary of State to investigate or consider disqualification under the 14th Amendment. The Secretary of State herself explicitly said there's no explicit
And I don't think
authority.
they're arguing that in the duty part of the language. I think I understand them to be saying if the Secretary were to put President Trump's name on the primary ballot, that would be a wrongful act because the former president, is not qualified to be on the primary ballot. So it's not an argument of dereliction of duty, it's an argument about a wrongful act. And under Kuhn, they're arguing we can look at other evidence that she might not look at.
I think Frazier answers the other wrongful act and rejected that expansive interpretation. And specifically, Frazier said the problem with that is that there's no limiting principle. I say that because I made that argument, and it did not succeed. And I will be honest, I think it's proper because in large part the Secretary of State said these expedited proceedings are wholly inappropriate for something beyond the election code because of the complexity of them and the incompatibility with this. And this is exactly, I think, what happened in this case, where we were denied all discovery, no initial disclosures, no opportunities for depositions, a limited time frame of 6 weeks to prepare our case from nuts to bolts to contend with 400 conclusions within the January 6th report, which became 100, which ultimately became 31. So there were a lot of infirmities in these procedures, and that was first and foremost, I would submit, in the Frazier Court's mind. Justice Gabriel, in his dissent, said, well, that can be and should be resolved with respect to a management order, a case management order in the trial court below. I think that optimism was probably misplaced, as proven by this particular case. So this was, in fact, in substance and in consequence, constitutional litigation. This was not a duty under the election code, which is what 113 requires. The reason why 113 has expedited procedures, the reason why they are appropriate and tolerated and endorsed in the election context is because they are generally simple, straightforward duties that don't involve complex constitutional litigation.
So is the rule that the Secretary has authority if it's simple and not complex, but doesn't if there is? I mean, it's hard to articulate a standard like that.
I think the standard is the constitutional standard. To be sure, a residency requirement like the type that was litigated in Kuhn can be complex. Not complex like this. That's like a constitution with the same as the consequences of it.
Complicated is never this.
Well, your court equated it, but the
I heard your answer to I
I'm sorry to interrupt before you go into the second, but the framers took a whole lot of the fact that the electors were going to protect insurrectionist former President Jefferson Davis.
Yes. No. 100 years. It wasn't 100 years until a Southerner got elected. Now, I'm not saying Jimmy Carter was an insurrectionist by any means, but before you even had a Southerner elected. So not only was it not absurd, but their framework and approach was successful. It was very successful. And when you look at the actual language, look, if you look at the structure of the text, it is harmonious. It was very carefully drafted, and every indicator points towards excluding the presidency and the president. Officer of the United States is used in 4 different contexts of the United States Constitution, every one of them which excludes, properly viewed, the president. The appointment clause, of course, there's been a lot of discussion on.
And so fair enough. So what is it does also refer to repeatedly the office of the president and the like.
Office under the United States, officer of the United States.
But when it talks about the president,
Yes,
it describes that as an office.
Correct.
So the president is an officer. What is the president an officer of?
So the, if I can find my notes quick enough, the analysis that has been found is that the president is an officer of, to the extent we have that concept of the Constitution. So an office under the United States is one created by the United States government. An officer of the United States is one that serves the United States government. And there is precedent that says, look, senators, representatives, and the presidency, president, they are the government. That's sort of the analysis, the distinction. And look, opposing counsel pointed to the emoluments clause as absurd. How could you possibly believe a president would not be part of the emoluments clause? Well, I would suggest you walk into Mount Vernon, and you will see above the fireplace a full-length portrait of King Louis the 16th that was given to George Washington by the French government. And no one batted an eye. It was never viewed as a violation of the emoluments clause because no one thought that it applied to George Washington. There's also the key to the Bastille that was given by a representative of the French government.
We've got enough on our hands without emoluments, right? So,
but I wanted to point out that the structural point, that it's all consistent with the president not being a part.
Let me just harken back to something that was said by opposing counsel, and that is, maybe we shouldn't be so quick to attribute significance to what the framers did with Article 2, Article 6, given that we're talking about framing and ratification that occurred during the Restoration. So maybe it's part of the puzzle, but is it really all that illuminating when we're talking about 80 years difference, and shouldn't we be looking to other sources given that amount of time?
I think it's very illuminating, Your Honor. I mean, the one thing I think everyone would agree on would be that the framers of the original Constitution, like the drafters of the 14th Amendment, spent lots of time thinking a lot of deep thoughts about the exact language that should be used. And I think we should all assume that those words were chosen with care. And the words in Section 3, in multiple ways, mimic the exact language of the underlying Constitution. Officer of the United States. They use that phrase exactly. They use office under the United States. They don't use officer under the United States. No one ever uses that language. It's office under the United States, officer of the United States. The oath. So here's an important point I would make. Petitioners say, well, they're synonymous. Doesn't matter. They really sort of include the same. But if you think about what actually happened with the framers, they have before them a United States Constitution, the original Constitution. The drafters of the 14th Amendment. And there are 2 oaths. One that clearly applies to the president, and one that clearly applies to appointed officers.
Although, as Justice Marcus pointed out, there's no language under Article 6. It just says swear an oath.
An oath.
There is language. The language says to support. Now, people interpret it differently, but that's the language of the Constitution. And my point is this. The drafters of the 14th Amendment said, What oath am I going to choose? They chose the Article 6 oath. Remember, they had before them choices. They could choose the Article 6 oath. They could choose the Article 6 and the Article 2 oath. They could choose neither oaths. Or they could choose both of them. They chose one and one only. The one that did not include,
The
that
one
was
that
different.
covered everybody. I think that's also, it seems to make no sense to me. I'm going to circle back to the absurdity argument that if the purpose of Section 3 was to punish oath breakers, that you would set up a provision that punishes those who break the lesser oath, but exempts persons who break the arguably more serious oath to preserve, protect, and defend. What is the rationale for that type of exclusion?
Is it a lesser oath versus a more stringent oath? I think that's a presumption we're making that may or may not be warranted because there's not much case law defining the two.
So can you make the argument that an oath to support is stronger than an oath to preserve, protect, and defend the
Yes.
Constitution?
Preserve, protect, and defend are specific words, specific actions. Support is a general category and far broader. Support can mean all kinds of things, as
Like
shown.
preserve, protect, and defend.
It can mean that, but it can mean other things. Or it could be viewed as narrower. The preserve, protect, and defend are very strong charges, and support is to help those who preserve and protect.
And so the logical consequence of that, though, is that the president doesn't have a duty to support. I mean, that's your argument, right?
No, my argument is this. My argument is that the drafters chose specific, and the language they chose was language that the underlying United States Constitution treated as separate things. We can argue about whether the underlying Constitution should have treated them as separate things. We can argue about whether functionally they should or should not be separate things, but the drafters of the 14th Amendment made a choice.
I think that what we're asking about is the meaning, and what you're arguing about is the meaning. And what I hear you saying is support is a lesser standard.
No, what I'm saying is this. I'm saying the meaning is that the drafters chose to exclude the United States, the presidency, by using specific language. I'm sorry, the president, the officer of the United States. My point is the drafters made a choice to exclude.
Why?
By choosing the support oath language, which mimics exactly Article 6, which applies to appointed officers, and they did not choose the Article 2, which applies to the president.
And I guess I read a lot of briefing over the last couple of weeks. I saw no rational reason for that type of an exclusion.
The historical record is devoid of that discussion. We can make it up here. We can come up with ideas.
We have a lot of historical evidence to the contrary, suggesting everybody thought that it did include Jefferson Davis.
I would suggest that there's a real paucity of evidence. When you actually analyze the citations made by the petitioners, it comes down to roughly one or maybe two newspaper articles during the entire ratification debates. I would not concede that point, Your Honor. I do not.
Can you come up with a rational basis for excluding either the office of the presidency or someone who swore an oath as a president
I think
from the Section 3 disqualification?
the answer is yes. And I think that the drafters, they rejected McKee's draft. They removed the presidency, the president, and they added presidential electors in. And
I
that was the
understand the
mechanism.
textual argument. I'm trying to understand the basis, the rationale. Why?
I think that is the rational argument.
The rationale, not the rational. With an E, rationale.
I think that is the rationale, Your Honor. I just do. I think that's what we need to accept, is that the framers, the drafters of Section 14 made those choices in that era, and it's not absurd because it worked.
So the choice you're saying is that they chose to include the electors instead of the president?
Yes.
But to accomplish the same purpose, in other words, the electors, if this were as designed, would prevent anyone in that situation from assuming the office. So why go about it indirectly when you could just go about it directly?
I guess we go into a more, I don't want to use the word metaphysical, but a more abstract argument is, if the entire nation chooses someone to be president, can that be an insurrection? Or is that democratic choice? remember, the president is a little bit different. Everyone in the country has an opportunity, or should have an opportunity to vote for that person.
Go ahead.
I don't think anyone here is suggesting, and I don't take the petitioners to have been arguing that the election of a person as president is an insurrection. I think that what the insurrection might have been is a different question. So I'm not sure where you're going with that argument.
I'm going with the broader context of the president is different. And if everyone in the country chooses a particular person as a president.
So if everyone chose an insurrectionist, look, Jefferson Davis, let's use that example. If Jefferson Davis ran a while ago, and the electors who were not themselves insurrectionists chose to put him into the presidency, that would be fine under Section 3, and that would be consistent with the purposes of Section 3.
That would be the rule of democracy in work.
But the rule of democracy, there are limits. I mean, the president can't be under 35 or can't be, someone who wasn't born in this country. So you could, the argument, if you take your argument to the limit, it would say we can elect Governor Schwarzenegger or, my 27-year-old kid.
I don't think it goes that far. It's that rule embodied in the text of Section 3. Now, there are plenty of anti-majoritarian measures in the structural constitution, and there are these qualifications. No one argues that. But when we're interpreting Section 3 of the 14th Amendment, and we look at the history behind that and the context and the language they used to satisfy the conditions of Section 3, you have to be an office under the United States. You have to hold the office under the United States, and you have to be an officer under the United States, and you have to take an oath. You have to have all four of those items in place. Any one of them, Section 3 does not apply.
Stepping away from Article 3, though, for a second, and sticking with the Constitution, could the Democratic Party put President Obama up on the primary ballot? Could that happen?
I haven't done a full analysis of that particular provision, Your Honor. I'm really sort of focused more on Section 3, but could they do it? Conceivably, I think it's an open question. If you look at the political question analysis of the Article 2 courts, the weight of authority was that states could not prevent that.
If I understand your democratic process argument, that would seem to be the logical conclusion. I'm just trying to make sure I understand the breadth.
The breadth is confined to Section 3, Your Honor.
But stepping away, because you were focused also on the Constitution.
Look, I'm focused on the structural Constitution to look at the language. The officer of the United States is used 4 times in the structural Constitution. And each time it does not apply to the U.S. president.
Go ahead.
I mean, not once does it apply.
No, I know.
Officer of.
You didn't answer my question, but that's okay. I'm not going to. I want to let you use your time the way you want to use your time.
So I feel like
Please feel free to take another run at me, Your Honor. I do want to be responsive. Yes, sir.
I feel like we're going in circles to some extent right now. I'm just wondering if we could shift gears. I was hoping to talk about the First Amendment and Brandenburg. Obviously, you've briefed at length the assertion that President Trump did not advocate violence in his speech on the ellipse, and so the counter-argument to that is that we have to look at context, and they assert that we should, well, the trial court obviously did place a lot of reliance on Professor Simi's testimony and coded language. I'm just wondering if you can give us your perspective on the extent to which precedent allows for that kind of analysis. I struggle with what I see as a lack of precedent on that particular issue, how far context goes. What's your take?
Context plays limited and probably almost no role. Now, this isn't a case, the incitement, and obviously we contest that incitement is part of Engage. Happy to address that as well. But this isn't an instance of sort of joint planning or a joint agreement where President Trump had specific conversations of back and forth. That's not what this is about. It's about inciting based on his public speech. That's what it's about.
So in saying that, I apologize for interrupting, but are you saying just look at January 6th and nothing else?
I will look at both, But to meet the imminence standard under the Brandenburg analysis, you have to look at just January 6th. That's really what you have to look at. And if you look at January 6th, his speech said, "Go peacefully and patriotically." He made 2 tweets followed by a video during the subsequent 3 hours.
But he also said probably 20 times fight.
He said it once, and he said, I was ready for this question.
Oh, okay, go for it.
And what he said is, he talked about that he was unhappy with what happened on January 6th, and people told him not to be involved. And he said, I am, because we have to fight. We have to fight in order to keep our country. He didn't say, and this may be splitting a little bit of hairs, but he actually did tell the crowd, go fight. He said, if we're going to protect, if I'm going to do the right thing, we have to fight. Okay? Now, the thing that Simi testified about in particular was that use of the word fight and the methods and language that President Trump used is perfectly consistent with normal patterns of political discourse. And in fact, we provided evidence that showed that fight like hell, fight like your lives depended on, those various iterations are used commonly throughout political discourse. So,
I'm sorry, finish your thought and then I'll jump in.
So the objective use of the language doesn't shift. I mean, we don't have a President Trump rule where if he says fight like hell, it's violent. And if other politicians, and we included senators and President Biden uses the term fight like hell, it's not an incitement to violence. We still look at the objective standards. I mean, we made an analogy to federal campaign finance law, Justice Roberts, who said intent and an effect test is not appropriate. You look at the objective words that someone uses. And the objective words, he said, go down, I know you are going to march down there peacefully and patriotically. He used 2 tweets saying stay peaceful. And he third made a video that said be peaceful and go home. Now,
I want to let you keep going.
now the petitioners are going to say, look, those tweets don't matter because he didn't say it right. He didn't tell people to go home. He just said be peaceful. But the objective language is saying be peaceful. And we produced one witness on the stand who said the instructions I got from President Trump were to stay peaceful because he heard the speech. Yes, sir.
So this just keeps reminding me of something I struggled with as I tried to evaluate this particular piece of it, and that is that are we not dealing with clear error review of the trial court's factual findings about those circumstances? And I realize that from your perspective, a lot of those findings were predicated on a report that never should have come into evidence. But setting that to the side for one moment, aren't we, to a large extent, stuck with the trial court's findings findings that were made by clear and convincing standard, even though you chose not to brief the preponderance of the evidence issue that you outlined in the application? So I'm sort of throwing multiple issues in here, but I don't know that we are in a position to say that there was clear error with respect to her findings of his intent and what happened that day and what led up to it, including the reliance on Professor Simi's testimony.
Well, I don't think it's clear error to apply the facts to the proper legal standard. And the court used the improper legal standard in determining what is in sight. Look, the facts are relatively uncontroverted with respect to what actually happened, because the petitioners rely entirely upon tweets, videos, and speeches. I mean, that's their case.
But there are inferences that are made, particularly by Professor Simi, about what significance should be attached to things that happened before January 6th, right? So,
and that's a legal standard. And we are saying that the events, the tweets and speeches in the years leading prior is inappropriate under the Brandenburg imminence standard. And that is a legal standard, and they should not be considered. So, and we didn't even dispute the underlying facts. We do, of course, dispute the inferences. And I would note that Professor Simi himself said that he did not address intent at all.
Although the trial court did, right? I mean, she found specific.
And it's clear error for her doing that.
Okay.
I mean, that is clear error in those conclusions. But this court can nonetheless review them because it's the application of facts to the improper legal standard. And the facts are the tweets. Look, the facts are all public tweets, public speech, public videos. And we don't contest any of that, what President Trump said in the evidence that was presented at trial. So I think this court doesn't need to look at the clear error, because look, it was not just engagement, insurrection. And let me just talk a moment about insurrection. Justice Gabriel, I think a couple folks brought up the different definitions. We have a consistent definition. I think you did as well, Justice. Look, the proponents of liability for Trump used...
Not liability. You said liability for Trump?
Or that Trump should be disqualified, the proponents...
Okay, but we're not, again, this isn't a Section 3 claim where there's any kind of liability.
Yeah, I misspoke, Your Honor.
Okay.
There's 2, 4, 6, 7 different definitions. The petitioners, in their complaint, I'm not going to spend time unless you want me to read each one of these, but the petitioners in their complaint advocated one standard. Professor Magliocca advocated a different standard. The court adopted yet a different standard. Bowden-Paulson have had yet a fourth standard. Professor Graber provided a fifth standard. The cite to Judge John Kane's grand jury charge, which we don't think has much force, but it has yet another standard. And the Simon Greenleaf treatise that was relied upon has yet another standard. Those are all different standards, 2 of which have been propounded by the petitioners themselves. The petitioners say, it doesn't matter. They all include President Trump. They all include him. But I would suggest that the fact that the actual proponents of this proposition have themselves identified 7 separate and distinct standards, some of which require a public use of force, some of which don't, some of which require a hindrance, some of which don't, some of which apply to the Constitution, execution of the Constitution, some of which don't and apply to the execution of a law.
Why don't you focus, because your time is limited, on the one the district court adopted? Any public use of force or threat of force by a group of people to hinder or prevent the execution of the Constitution. What's wrong with that definition?
Way too broad. I think the petitioners actually admitted that a group of people threatening a mailman and preventing him or her from executing their constitutional duties, because that's one of the constitutional powers that Congress has, would constitute an insurrection.
What if we narrowed it to say prevent the peaceful transfer of power of the United States government? Would that be an insurrection?
To prevent the peaceful transfer? I don't think so, and I'm not sure, Your Honor. Look, if you look at historically in the context of how insurrection was used, it has to be for a substantial duration, not 3 hours. There has to be some geographical scope. There has to be a goal of nullifying all governmental authority in an area.
I guess I'm not sure where you said it has to be, where the temporal provision, where's all that coming from? Webster's Third New International Dictionary defines it as an act or instance of revolting against civil authority or against an established government. So you've added a whole lot of conditions there. I'm not sure where they came from.
I would urge you, I think probably the best exposition of that was the State Attorney General's briefs and the authority that they provided. Okay, but I think also if you look at sort of the historical record. Now you're going to tell me, Mr. Gesser, you're making it up. And I'm going to say, well, so did the judge. And I'll say, we're all sort of making it up at the end of the day.
Well,
yes.
I just want to jump in on this point of how I don't know that we have to come up with a test that's going to necessarily address all circumstances. I guess the question, at least as to insurrection, setting apart whether President Trump engaged in insurrection, but as to insurrection, why isn't it enough that a violent mob breached the Capitol when Congress was performing a core constitutional function? In some ways, that seems like a poster child for insurrection. Why is that not true?
Well, I think what you're sort of saying is the famous quote. I don't know a definition of it, but I know it when I see it. That we don't have a workable standard, but we think in this instance it doesn't feel good, and it just seems
Well, it's more than it doesn't feel good. For purposes of this case, what we need to do is figure out whether what happened on January 6th, one of the things we need to do is figure out whether what happened on January 6th constituted an insurrection. We don't need to come up with a definition for all times in all circumstances.
I think most common sense thinking folk would look at it and say, you have sedition at one end of the spectrum, and you have levying war is a term that you've used, civil war maybe at the other end, but in between we have these things, insurrection, rebellion. I think we'd agree that insurrection is typically something less than rebellion.
And I would agree with that in the case, and some of the authorities support it, but it's more than a riot. It's more than a 3-hour riot on one building.
Was that just a riot on January 6th?
I only think it properly characterized that way and not as insurrection. And remember, look, the Constitution, Section 3 says engage in insurrection. It doesn't say in an insurrection. What's the significance of that? I think that it indicates sort of a broader process rather than a singular, limited in scope event. And if you look at the Civil War, that was a broad four-year
That was
activity.
actually more than an insurrection, wasn't it? I mean, the Civil War.
Yes.
I believe levying war was the. I mean, insurrection is getting at something less than a war.
Likely, yes. Now, there are lots of instances in the ratification debates and the framing debates, and I think the AG's pointed this out in their memo, that insurrection, rebellion, war, treason are oftentimes used interchangeably by the drafters. And in fact, you look at some of the authorities here, the petitioners cite, they'll shift from insurrection in some instances and draw examples from treason or rebellion. So they are used very interchangeably. So we would argue that, sort of on the scale of violence and duration and scope and organization, the events of January 6th were more like a riot and far less than a rebellion. And insurrection is far closer to rebellion than it is riot.
How would you define insurrection?
Part of my whole thesis is that we can't define it, and that's in part why this is a non-justiciable question. But to the extent you push me, which you are, I would say it requires at least multiple considerations that go beyond what we had here. I think the duration has to be longer than 3 hours. I think the geographical scope has to be broader than one building. And you say, well, that was the U.S. Capitol. True. It wasn't the Pentagon. It wasn't. It was a singular node. The goal wasn't to nullify governmental authority and set up an alternative government. The goal, if one assumes the predicate that President Trump directed the crowd, which we reject, to get Mike Pence, Vice President Pence, to delay the certification. That's not nullification. And I understand it's violent, and I understand it's bad, but we, as I would submit, as lawyers in this process, need to distinguish those gradations because they have meaning. And what I would say is the goals were not as broad as something like the Shays Rebellion or Whiskey Rebellion. The organization, there was very little evidence of a robust command and control structure and that level of organization. The use of force did not involve arms, certainly not the level of arms necessary to overcome.
Let me just jump in there, Mr.
And it wasn't capable of being rebellion. Yes, sir.
The arms. I mean, you make a legitimate point about, there not being a lot of evidence of arms being taken to the Capitol on January 6th, but there were a lot of makeshift weapons that did a lot of damage. I think at least the petitioners are saying 170 people were injured. That's a lot of violence, right? You'd agree. And irrespective of whether people brought guns and knives to the event, I don't know that we need to, pause too much about that when we have that level of violence. What am I missing?
What you're missing is a riot is consistent with using flagpoles and broken up bike racks as weaponry. An insurrection or rebellion is organized, deadly force that's going to nullify government authority. I think there's a big difference there. And look, I understand that the violence of the Capitol was not acceptable. But I do think that it is our job to apply legal standards and understand the gradations involved and whether or not this truly rises to the level of insurrection.
Well, why don't you talk about engagement? You've only got 3 minutes and 40 seconds, so, and I'll just ask you a question to help move this along, hopefully. My concern, I guess, would be, I understand what the argument you make. Engage doesn't mean incite. Those are different things. A leader of an insurrection usually is not involved or frequently is not involved in the hand-to-hand fighting. They direct it, they organize it, and then they stand back and they watch it. That would be engagement, I would think, if you had an actual insurrection. So help me understand what engage means.
Well, I think that does. And what that requires is sort of a two-way conversation. Hey, you, sergeant or lieutenant, I'm the general. I'm going to do this, you're going to do that. That's different than public speeches. Now look, I mean, if there were a public speech and someone said, and made an agreement with the other side and say, when I say during my public speech the eagle has landed, then we take action. I would submit that that's engage. But that's a much different instance than incite here. Incite is to sort of arouse these emotions only through public speech. It's a one-way conversation.
So if a leader did a more direct, I want you, and let's make this hypothetical. A leader said, President, I want you to go to the Capitol and I want you to take it over and I want you to ensure that they do not go forward on the Electoral College and use violence if need be. That would be engagement even if the leader doesn't go with them?
Very likely, yes.
Okay.
Very likely, yes. If there is an understanding, an agreement, and not some broad inferential conditioning that Professor Simi testified, I don't think that meets the legal standard. But there has to be very definite sort of meeting of the minds that that's in fact going to happen for it to be engagement. Now, it could still be incitement because it's a direct call for violence, which did not happen here. But there is a difference between the two. They do describe. And I would point out that Congress has treated it as distinct. You know, you look at the Second Confiscation Act in 18 U.S.C. 2383, it says whoever incites, sets on foot, assists, or engages in any rebellion or insurrection. So they treat it as differently. And by the way, if I may say, at the end they say, incitement, sets on foot, assists, they shall be incapable of holding any office under the United States, which indicates that the presidency cannot be barred by mere statutes of Congress. So there's that language, under the United States again. Consistent usage and pattern of that. Let me just sort of end up in my, wrap up in the last minute here. This was constitutional litigation. Had the shoe been on the other foot, had the Secretary taken action, and President Trump would have been required to file a lawsuit, that would be constitutional litigation as well. And all of the dangers and infirmities that Frazier warned about, that Kuhn recognized, that happened here. This was an inappropriate forum for this. It should have been a declaratory judgment action. They could have fought out the standing issues, and we would have done that appropriately. And that's a pattern that has been followed in Colorado in the past. With that said, if you look at the text and the direct textual application of Section 3, it doesn't mention the president. And every structural piece that we've discussed, the natural and comfortable meaning points towards the president's exclusion. That fits in with the broader fact that it's not enforceable by state courts against a federal official. The court should not have engaged in insurrection. Certainly the January 6th report was deficient. We ask this court affirm the district court below, but also strike the dicta from the decision as beyond that court's jurisdiction. Thank you very much.
Thank you, Mr. Kessler. Mr. Olson, you got about 3 minutes, 46 seconds.
Thank you, Mr. Chief Justice. In short, Trump claims this case is too hard for courts to decide, that the standards of insurrection can't be determined, but that's exactly what courts do, and that's exactly what the district court did below. And to the extent there's a dispute between courts that reach these questions, our country has a well-worn mechanism for addressing those inconsistencies. I want to talk briefly about insurrection, the officer, and then end on the Colorado Election Code. Justice Hood, you asked how far context goes. It does a great deal of work. In Claver and Hardware, this court said, or the U.S. Supreme Court, Justice Stevens said very explicitly that evidence of authorization of wrongful conduct in other circumstances was relevant to whether the speech at issue there was within or outside the First Amendment. And because there was no other authorization, no other evidence. They found the speech protected by the First Amendment. Here, the district court made extemporaneous extensive findings that the speech by President Trump on paragraphs 288 to 298 were there's a long pattern of him saying things, seeing violence, praising that violence. He used those exact same words on January 6th.
Is Simi's testimony subject to clear error review? Are those facts that the trial court ended up making based on his testimony subject to anything other than clear error review here?
They're subject to clear error review, but the court didn't just rely on Simi's testimony.
No, I know.
She set forth a number of facts, of statements by Trump himself where there was violence. And in the speech on the lips, there were 20 times he called to fight, which is a literal call to violence. He said that 20 times. It wasn't in the prepared speech. He did that so that people wouldn't know that he was going to call people to march to the Capitol. He was going to incite them to violence. Hess also looks at a rational inference from the import of language. And there's no better evidence of what happened than evidence that Trump didn't object to below. And that was Brad Parscale, his former campaign manager, in real time on January 6th said, "We are seeing, quote, a sitting president call for civil war." That easily meets the incitement standard under the First Amendment. And I was amazed. There's a tweet at 2:24 p.m. on January 6th. Trump never mentioned it in his briefs below, never mentioned it at trial. When he was describing what happened on January 6th today, he ignored the tweet on January 6th at 2:24, which sent the mob into a frenzy. There was unrebutted testimony that poured gasoline on the fire and caused the Capitol to be breached. If this is not incitement, I don't know what is. Secondly, Justice Hood, to your question, using the on the ballot certification is under